This is a Legal Resources for the Elderly program presentation. This presentation is based on New Mexico law and is intended for informational purposes only. Because every individual's situation or problem is unique, you should always seek the advice of a qualified attorney for assistance with your individual concerns or questions. Hello. My name is Natalie, and I am one of the staff attorneys at Legal Resources for the Elderly program. In today's video, we'll be talking about the financial power of attorney. First, a bit about our program. Legal Resources for the Elderly program is a joint project of New Mexico's Aging and Long-Term Services Department and the State Bar of New Mexico's State Bar Foundation. Our program offers a free statewide legal helpline for New Mexico seniors age 55 and older. Our attorneys advise on a variety of civil legal issues, including powers of attorney, estate planning, Medicaid for long-term care, and much more. Our program has no income restrictions, so you can call up and speak with an LREP attorney for free. We will be going over the financial power of attorney. And so what is a financial power of attorney? This is a legal document that allows you, the principal, to name an agent or an attorney in fact to handle your financial affairs on your behalf. It's important to note what this is not. A financial power of attorney is not a substitute for estate planning. If you have questions about estate planning, we encourage you to call our program and get some advice from our attorneys. So why do you need a financial power of attorney? If you become unwilling or unable to handle your financial affairs, you will probably need someone to make financial decisions for you and to help you with your financial affairs. Without a financial power of attorney, if you become incapacitated and unable to make decisions, no one will have the legal right to handle your financial affairs. Moreover, without a financial power of attorney, family or friends may have to apply to the court for legal guardianship or conservatorship, which can be very expensive, very time-consuming, and it can cause delays in your care. So it's really important as a planning tool to have a financial power of attorney to ensure that continuity of your care. So you may be wondering who you should choose as your agent, and we recommend choosing the person who you trust and someone who's available. And that second point is just as important as naming someone you trust. Naming someone who is available is very important. We often have clients who will call our program and they want to name, say, a son or daughter living in another state. And that's fine, you can do that. You just want to be sure that they're going to be able to help you when the time comes. So making sure they're available is important as well. Your agent under the financial power of attorney has a fiduciary duty to act in your best interest. And so they should try to do what you would do for yourself if you were able to make these decisions. Under the financial power of attorney, you can also name successor agents who can take over responsibility of managing your finances if your primary agent is unable or unwilling to help. You can also grant your primary agent or one of your successor agents the authority to pass on the power to manage your finances to someone else. When we talk about financial powers of attorney, there are a lot of different terms that come up when we talk about these documents, and so I think it's important to highlight some of these different terms. First is the durable power of attorney. A lot of people hear this term durable, and so what this means is that in a durable power of attorney, in the document, it's going to state that this document will remain in effect even after you, the principal, becomes incapacitated, Without this durable clause in the document, the power of attorney may be void when you need it the most. So it's very important that any powers of attorney that you're signing are durable, that they're going to persist through your incapacity. Other types of powers of attorney. There is the immediate power of attorney. And what this does is it allows you, the principal, to give your agent the power to act on your behalf right now. So under an immediate power of attorney, you could execute this document, give it to your agent, and they would be able to go to the bank or other financial institutions and start operating on your behalf right away. With the springing power of attorney, you, the principal, give your agent the power to act on your behalf only if you become incapacitated. So if you sign a springing power of attorney, your agent isn't going to be able to act on your behalf until you are incapacitated. So you often hear a lot about capacity and incapacity when talking about powers of attorney. It's important to note that you must have capacity to sign a financial power of attorney. If you do not have capacity when you sign a document, it is not considered a valid power of attorney. And so what exactly does capacity mean? Capacity means that you have the ability to understand the nature and consequences of a particular action. You have the ability to make decisions, and you also have an ability to communicate those decisions to others. Oftentimes when we talk about capacity, this is going to be something that's determined by your healthcare professionals. There are some limits on your financial power of attorney. First, a financial power of attorney must be in writing and signed by you in front of a notary in order to be valid. With a financial power of attorney, you can revoke it at any time. However, this revocation must be in writing and signed by you, once again in front of a notary. A financial power of attorney is only going to be valid while you, the principal, are living. Your agent's power under this financial power of attorney ends upon your death. So for this reason, an agent under your financial power of attorney will not be able to handle your estate at your death. And that's why it's important, if you want to do any estate planning, that must be handled separately from your power of attorney. And if you have any questions about estate planning, once again, we encourage you to contact our program. Now that you've gotten some information about the financial power of attorney, if you wish to complete your own Legal Resources for the Elderly program does have a financial power of attorney form that you can download and print and complete on your own. We also have an informational video to help you complete this financial power of attorney. As always, you can visit our website to find this form, the informational video, and many other resources about other topics. If you have any questions about this video, about the financial power of attorney or the form, or any other civil legal matter, we encourage you to contact our program. You can reach us statewide toll-free at 1-800-876-6657 or locally at 505-797-6005. We encourage you to call our program if you have any questions or concerns. Thank you for watching this video.